Hello and welcome to The View from 22 from The Spectator. Each week we're going to discuss a topic which we think hasn't got enough pick-up in the national press. And this week we'd like to talk about the online safety bill. It was introduced, work started on it several years ago. Theresa May was all set to introduce it. Then Nadine Dorries was a champion of it. Rishi Sunak changed it, has decided to still go ahead. Is it still a threat to free speech? Is it still a threat to the free press? As editor of The Spectator, I have argued that it is, but one of the most articulate defenders of the bill is Damian Collins, former tech minister, who joins me now. Damian, welcome.
Thank you.
Now, you say that, I agree with you, that the tech, we're in a strange situation where tech companies have created the public space. So now when people are having a debate, increasingly they're having a debate on forums which were created and are owned by the likes of Facebook, by YouTube. Our discussions happening on YouTube. Whether somebody's watching it right now will depend on whether it was recommended by YouTube. Now, what discomforts me as an editor is I noticed all the time that how much our fortunes change depending on the content. For example, if you and I were to discuss the safety of vaccines, that would immediately flag it up to the YouTube as a potentially dodgy conversation, and perhaps our viewers would be far less likely to see it. So I've noticed the real power that these digital companies have in basically deciding who watches what. People assume their Facebook feeds are curated by the people they follow, but no, Facebook decides or edits. So they've got more power than a Murdoch, than a Hearst, than a Beaverbrook. Amazing power. What unnerves me is the idea that the government might be directing these guys, so you get big tech plus big government to put together a kind of power composure which could be open to abuse.
Well, I think you're right to raise it, and because if you go back to the days of Lord Northcliffe, where he printed a third of the newspapers read in London every morning were printed on his presses, well, 2/3 weren't. And if you went to a newsstand, you had a choice of what you got. If your newsfeed on Next Up on YouTube or on Facebook or wherever, whichever social app you use, is largely directed by recommendation, and that recommendation steers you largely towards the same thing, that gives immense power to the people who have those recommendations.
And we're talking billions, aren't we? We're not talking the Northcliffe, you'd be lucky to have a couple of millions. Yeah. But the people who get there, I think Facebook is now the number one provider of written news in Britain after the broadcasters.
Absolutely. And you look at all the data that shows, and I say younger audiences, by that I mean people under the age of 40, not just students or younger people than that. They're principally getting their news from social media. They're not even going to a news website to get news that's been edited for them. So the role of the news editor in determining the issues they thought were important, the priority they attached to them, the way they were laid out, that is bypassed by an algorithm. So we should be concerned around the power that lies behind that algorithm and how it's directed and how that is influencing the way people see the news and the world around them.
So tell me what the online safety bill would do for this. Would it offer any transparency over this process?
Well, it does, I think, two quite important things. One is it says for news, with regards to news providers, it says to the big platforms, it can't be right that you, YouTube, are effectively the editor-in-chief for every news organisation that distributes its content through your platform, which means that your platform policies set effectively editorial standards. So if they're publishing a story you don't like, you can either kick it off the platform or you can downgrade it.
And often with no explanation given. I mean, we once had our columnist Lionel Shriver read out her column on YouTube, and we found it demonetized. It was targeted by their bots. And it was very difficult to find out why. I think David Davis gave a speech protesting against vaccine. It was the lockdown measures.
Yeah, that's right. And
that was taken down by YouTube. So again, amazing power just to blackball this, that, and the other.
Exactly. I mean, Talk Radio. There was a case with Talk Radio. They had a show that they podcast on YouTube, and the whole channel was taken down because YouTube disagreed with it. It was restored, as David Davis's speech was. So
what all that power surely is still in place with the online safety bill.
So what the online safety bill does, though, it says to the platforms, you can't interfere with news publisher content unless you've given that news company the right to appeal against a decision you might make. So you could have a month of an appeal process whereby for the news company, even if they lose the appeal, that the currency of that news item is still valid, it's still there.
But we can appeal at the moment. We do. We lose, but we appeal.
But at the moment, you'll face arbitrary takedown, so they will just remove, you have no right to appeal. What the online safety bill says is the company can't remove unless they've gone through an appeal process. So
but removing isn't the trick, though. I mean, it's interesting to see what we're talking about here. There are many ways in which you can be penalised. penalised. Now, very seldom is a Spectator article removed, or is one of our podcasts or videos removed. All that happens is that we can notice that it's got far fewer hits, and that's because it's been targeted in a way that we don't understand. Now, with YouTube, huge amounts of power comes on what to watch next. So people might be watching our discussion on YouTube.
Yeah.
Right now, they'll be said, you might want to read A, B, and C next. Huge amounts of power. Something YouTube doesn't favour, it won't be taken down. It just won't be recommended.
Yeah.
But there's nothing really in the bill to increase the transparency over that, is there?
Well, so I think this is a really, really important issue, and it's not one that is directly addressed in the online safety bill, but I hope will be addressed in the digital markets bill that the government is going to bring forward in this session. So that's been brought forward. Because I think here you get into a really interesting area that a number of news publishers have been complaining about, which is that do recommendation tools on Google or YouTube or on Facebook, do they seem to recommend, they seem to prioritise some news organisations over others? Why is it that some always seem to be in your stream of recommended content, but not others?
Or some lines of argument over others. I mean, that's my broader concern, because if you're in the business of against the grain journalism, as the Spectator has been since 1828, that's when the bots are more likely to spot you. If you're simply reinforcing the consensus, the bots don't go against you. But if, for example, you're saying something about, I'll give you a very good example. When we commissioned Professor Carl Hennigan from Oxford to write an assessment of the science over face masks. Now, Facebook slapped a label on there saying false information. Now, Facebook to this day will refuse to tell us why they put that label on it, which to me is quite amazing. If I'm publicly accusing you of false information, then a matter of decency, you'd expect me to say why I think you're false. But Facebook doesn't do that. But the thing is, but you say that you might hope to get this in a second bill, but the online safety bill doesn't do any of this. I mean, I'll tell you what my concern about it is that this is happening. This bill has been, the online safety bill is, 4 years in the making?
Yes, yeah.
A long time.
Yeah.
During those 4 years, technology has advanced so much that the threats we're talking about now simply isn't addressed. And in fact, you guys might make it worse, because what you're doing in this bill is you're saying to the online company that we will give ourselves, Parliament, the ability to fine you what's up to 10% of global turnover, which is billions upon billions of dollars. So that will make them intrinsically risk averse and more likely to block or downgrade arguments that go against the grain.
Well, I disagree with that, but I want to come back to that. But if I can just go back to a point you made just a short moment ago, which is to say, in terms of like news publisher content, so there will be some protections there for news publishers which don't currently exist. The other thing the platforms will have to do is demonstrate how they give due regard for freedom of expression in the decisions they make over moderating content.
Due regard.
Yeah, so they'll have to demonstrate to the regulator, have they considered, well, if this content, there's no legal requirement why it should be removed, if it's not in breach of the platform's terms of service, yet they're still downgrading it, why are they doing that? And so there will be, to your point about what sort of transparency will there be, Ofcom can demand transparency on that. But
wait, the phrase due regard is a joke, isn't it? It's meaningless.
Well, no, I don't think it is, because what it'll do, it will bring transparency. There is none at the moment, because as you yourself said, you've got no right or no way of knowing why they're making these decisions. Well, Ofcom can expose that. I think there is a question for the bill as to what power should Ofcom have to intervene where companies are removing content where they've never said they would remove it. There's no reason why they should, and yet they're doing it anyway. And at the moment, we have no transparency over that. And the bill will give us some transparency.
How will they give you transparency? Because as far as I'm aware, say our conversation now gets thumbs down from the YouTube bots or algorithms. YouTube is under no obligation at all to tell us this, and under the legislation, it will also be under no obligation to tell us. We would only know when we find out that our conversation has got a fraction of the traffic that it normally does. What I'm saying is, you verbally here, you recognise the problem, but the bill will do nothing to oblige social media companies to inform the publishers when it has punished, targeted, or downrated their content.
Well, Ofcom can ask for that information. Ofcom as the regulator will have the right to challenge companies on that, to say, are they making interventions to prevent content going viral, reaching the audience it should naturally reach?
But of course they are. We're doing that on several thousand times a day.
Well, there are two things at play here. There is the recommendations they make. There's also the way I think external organisations can gain content on the platforms as well. And you see a lot of activity, through bot accounts seeking to drown out legitimate content and news and promote other content, often fake content, to drown out other sources of news as well. Now, there's a question about what sort of action do the platforms take to try and protect the quality of the information that circulates on their platforms. And when you talk to journalists like Maria Ressa, working in the Philippines, this is the biggest problem that she faces. And her big concern that if we don't regulate that legitimate journalism gets drowned out, is that it's not just about what the platforms do, it's about the fact that the manipulation of thousands and thousands, millions of fake accounts are actually changing what people see, and you can just take legitimate journalism and bury it under a pile of...
That's not really happening. It might be happening in the Philippines, but it's not really happening in Britain.
I think less so in Britain, thank God.
Right, but the legislation is for Britain, right?
No,
so let's stick to Britain.
Yeah, but you point you made around sort of algorithmic preference. It works two ways. Are companies making decisions to deliberately downgrade content, and why are they doing that? At the moment, as you said, we have no transparency. The bill will give Ofcom the power to find out and to determine that. And that works for freedom of expression. And principally, the core objective is actually working to deal with content that is illegal, content that is, because of the nature of its illegality, will cause harm as well. But you said earlier on that you were concerned that that if we set these standards, if we start saying to tech companies, if you don't remove this sort of content that's illegal, then we're going to fine you, and they will just remove more and more.
Yeah.
Well, I actually think what we should do in this space is to say, well, the standards of how platforms are regulated, the standards that determine the things that they allow and they don't allow, shouldn't just rest on arbitrary decision on their point or their own terms of service. What we should do is say, we have legal standards for many that cover many areas of speech. So things that incitement of racial hatred is a criminal offence. We have incitement of violence. Is a criminal offence. People are prosecuted for these things. The minimum safety standards you set should be based on our laws. If you set higher standards for yourself, then you should be held to account for whether you enforce them or not. And our regulators should have the right to know how you do it and why you do it, and have the right to produce data from the company. So if a company promises that it won't allow hate speech on its platform, well, actually, how does it determine what hate speech is, and how does it enforce those rules?
Well, tell us. Well, how is it defined under the legislation?
Well, the legislation will take the minimum safety standard is based on the legal threshold. So if you take race hate, and I think the case that's often cited in this debate around the race hate that was directed towards the England footballers after the final of the European Championships. Now, people were prosecuted for what they posted on Twitter and Instagram. We've got an established case law where we know what the minimum legal standard is. We know where the intervention should come. So we'd say to the platforms, what the bill says to the platforms is, your safety standards should at least be set at that level. You should be looking to proactively identify that sort of behaviour and mitigating it.
But what happens if there are unintended casualties of this?
Well, the platforms are not required to go above that. They may set a higher standard.
They will, and what happens when they do? What happens when they take away legitimate comments because they've misdiagnosed something as...
Well, if that happens, that's far more likely to happen because it's they're enforcing their own terms of service. In most cases, I would say the terms of service of the platforms probably sit above the legal threshold.
Right,
because the minimum standard should be based on our laws, and there should be proper enforcement of that, because my concern would be most of the time the companies say they will do things in their terms of service and they just don't do them.
Right, but you're coming at this thinking, okay, by the way, every time there's a restriction on free speech, it always starts off with an example nobody could argue against. And nobody would think there should be vile racism online. Nobody thinks you promote terrorism or buying guns or buying drugs, etc. But the next thing you know, Nadine Dorries is talking about the jokes of Jimmy Carr. She mentioned that in House of Commons as being something she would like to take action against. You yourself have mentioned Andrew Tate as being something that... Tell us about Andrew Tate.
Well, so I think the concern with Andrew Tate is whether not just the content he's publishing, but content that a movement of people that really is around him are promoting, I think, misogynistic attitudes towards young teenage boys. And the concern here is it's not just what you started with. It's about the preponderance of content as well. So for children in particular, which is where the principal concern around Andrew Tate has been raised, are children seeing a preponderance of content from him, which actually is in breach of the community standards and could be harmful to children. And therefore, what sort of intervention?
Can you elaborate on harmful?
No, what sort of intervention do we make at that point?
Well, no, so, okay, I think it's important here to say, because harmful is a test which you intend to apply. Social media companies are threatened with huge fines if they get this wrong. So when you say Andrew Tate is coming up with harmful content, if I'm YouTube, I'm thinking, okay, you intend to fine me, I'll take that seriously. But please, Mr. Collins, give me an example of what Mr. Tate has said that is harmful.
Yeah, so the decisions that have been made at the moment with regards to Andrew Tate have not been made as a consequence of the online safety bill. They're decisions that the platforms themselves have made because they think his content breaches their community standards.
But you seem to have a problem with Andrew Tate's
content.
content.
I think that I do have a problem with Andrew Tate's content, particularly as it's been, I think, directed at scale, been promoted at scale by platforms to children, and that I think is inappropriate.
Would your legislation change this?
Well, no, so the legislation requires Ofcom to work with the companies to determine what are the safety standards they set for children, which could be different for adults. And unlike with adults, there are risk assessments of that content. So we get data and information. We can see what the companies are doing, what decisions they're making. But I've always taken the view with the bill, and in the long gestation period of this piece of legislation, the sort of 4 years, the thing I've urged for constantly, and I think has happened, is for us to be far more specific about what it is we want the companies to do.
Well, can you give us then a specific? Can you give a single example of what Andrew Tate has said that you wouldn't want a child to hear?
Well, no. So I think with Andrew Tate, that at the moment is principally around the companies, the platform policies the companies set for themselves.
Right, but they'll be wondering what you mean by this. I mean, so I've got a teenage boy. He's 15 years old. What is it that Andrew Tate says that you think you shouldn't be hearing?
Well, I'm not going to give a list of everything Andrew Tate or his followers have said. I'm saying
you're proposing passing a law, though, are you?
No,
that would put social media companies on the hook. And they'll be left wondering, what do the politicians mean by this? No. But when they try to find out, all of a sudden it gets very vague.
No, so I think, no, not at all. That's why I said, if you look at the legal standards we want to set, what we've done is bring onto the face of the bill to say, well, if we're saying there are things that are a breach of our laws, we want the companies to apply, what are those laws? So on the face of the bill now is written, those offences, those priority legal offences that exist for all adults. And that is a far wider range of specific offences than was there before. So and that, I think, gives a lot more clarity as to which offences we're talking about, how might they be enforced.
For example?
Well, so for example, the bringing in inciting racial hatred, bringing in harassment, where we have legal case law that's set on the statute books. The courts have interpreted it. We've said these are the safety standards. So where companies see content like that, their obligation, their duty is not to mitigate it. And up front, they will agree with the regulator, codes of practice where they agree. They say, well, these are the standards we will set. This is how we interpret what the law says. Here are, in addition to that, are our community standards. This is what we will do. And that's agreed up front with the regulator. It's laid in front of Parliament, and that is the basis of regulation. But more than that, what Ofcom has got the power to do then is to go into the companies and say, well, show us you're doing it. We want information to say, how do you police this? How do you enforce it? How do you make sure that you're not over-enforcing? You're not removing stuff where you've got no right to be removing it because it's not a legal requirement, it's not your platform policy. That is the framework within this work. So I think that what that gives us is two things: much more certainty on what it's based on, codes of practice where it's written down in terms of exactly what will happen. And these are based on our laws without our regulator overseeing them, rather than just being arbitrary decisions someone in Silicon Valley makes where we've got no idea how they make that decision or how they enforce it or if they enforce it.
Right. But let's, okay, though I do notice that Andrew Tate seems to be your Jimmy Carr because, you don't like him very much. I get that. You can't name a single thing he'd done that you think would transgress any law right now. Not just that, any sort of decency boundary that you might want the social media companies to enforce. And that's the problem, isn't it? They have to guess. Now, let's take my colleague Rod Little. Are you familiar with this oeuvre?
Yeah, I am, yes. Yeah.
Right. Now, he did a DNA test recently, and he hoped he'd be 90% English and 10% Viking, he had hoped. In fact, it turns out he's mostly Scottish. Now, he took quite badly to this, and he wrote a column about this. He said, isn't this terrible? He said, I turn out to be majority salad-dodging smackhead. That's how he described a Scot like me. Was that race hate?
Well, I don't think. I mean, people might not like it, but I don't think that is race hate.
But you can see how that might get judged by a bot, can't you?
Well, so I think what you mean by that is if the platforms say, well, we don't like that content, therefore we're either going to downgrade it so no one sees it, or we're going to remove it altogether. What the online safety bill does there is to say to the companies, to say, well, you're making that decision. On what basis are you making it? Is it in breach of your community standards? As a company, they've got a right to set standards if they want to.
But how do I know? Say I publish this,
yeah,
and I find out that Rod has referred to my fellow Scots. Indeed, he's Scottish himself, as salad-dodging smackheads, not very polite. But they've taken it down, but I don't know that as a publisher.
Yeah, but that's why we have the publisher exemption, which I think is important, because what you do as an editor is you put your name to everything that you publish. You are the person who is liable and responsible for those decisions you make. So if someone doesn't, if you publish something that someone takes great exception to, they can take you to court. That's the decision you take. And that's why we don't want to take that power away from editors. We want to protect editors to carry on making those decisions. The vast majority of the content that we talk about often online as being illegal, well, particularly the stuff that is illegal. The reason the online safety bill is important is that those people don't have the liability you have. They're not putting their name to what they say. They're not traceable. They may be out of jurisdiction. And so what the bill is really saying is we're recognising that actually the platforms have a responsibility and have a liability because they're the ones that are actively promoting this content to other people. And they're doing it to make money.
Damian Collins, thank you very much for joining me on The View from 22.
Thank you.